Contract Law Part 1. Specific contract laws vary between states and localities, so it is always a good idea to have a legal advisor who is familiar with the local laws and any changes. There are, however, standards that apply to most legal contracts. Competency. Anyone who enters a contract must have the ability to understand the contract. Typically, minors or individuals who do not have adult mental capacity are not considered competent. There are tests available to determine legal maturity. A contract that lacks competency can easily be invalidated. Writing versus oral. Oral contracts occur in everyday purchases as the swapping of money for goods implies a contractual agreement. Oral contracts are legal, but they are not always possible to prove, specifically the exact terms. Written contracts are always a safer option. Good faith agreements, letter agreements, and understandings all offer additional protection. Many states have statutes requiring written contracts in order to prevent fraud. Contracts that typically need to be in writing include surety or guarantee contracts, contracts lasting longer than a year, land-related contracts, sales and leases, sales over $500 and leases over $1,000, sales of bonds or stocks, wills and other bequeathals. These fraud statutes will vary between state governments. Contract Law Part 2. Modern technology has changed the way that people interact and do business, including contracts. Transactions and agreements are made online daily, and they are governed by federal and state legislation. Online acceptance. Online contracts, such as in software, have buttons that indicate an agreement to terms. Clicking these buttons is a legal acceptance according to most court cases. Online commerce. The Uniform Electronic Transactions Act and other state and federal laws monitor commerce online and websites. In most cases, the laws require business names, addresses, refund policies, and methods for complaints must be prominent for a contract to be upheld. Electronic signature. Electronic signatures are legally valid, but it must be possible to duplicate them, and they are not obligatory. There are limits for electronic signatures, including the family law, health-related actions, evictions, and foreclosures.